Hi, everyone. So I've talked about arbitration at a lot of these, and every year I come up and give what's called a legal update, which is really just a sales pitch for arbitration. And this year will be no different. And I think this last hour and a half or whatever was kind of like a good segue because I have such sympathy for all of you trying to comply with all these new laws as well as the stack of old laws. And inevitably, as you all know, something goes wrong. Somebody makes a mistake, some T is not crossed, some I is not dotted. And ultimately, those can result in things like lawsuits. And in every case, I will tell you, and some of you I've worked with, when someone calls me and say, "We got this lawsuit. Here's the claim. This bad thing happened," I don't ask, "Did it happen?" I say, "Did they sign an arbitration agreement?" And that's the first question because it really sets the tone for what's going to happen next. Because very often, if you tell the other side there's an arbitration agreement, they may just drop the claim. They will settle for cheap. Or even if they don't, you know that it's going to be resolved faster, cheaper, and probably with a better result than if you were to go through, say, LA Superior Court, where juries throw around $10, $20 million verdicts willy-nilly, okay? So this year, I had very good news because in previous years, I came up and said, well, there's like these big major questions over like, can you have arbitration? What's carved out, what's not? Over the last couple of years, we've gotten a lot more clarity. And this year, there haven't been too many new questions raised. So I'm just going to run through the updates. Jeremy told me to go fast, so bear with me. Okay, so here's the most important slide for you to know. This is the current state of the law. Mandatory arbitration agreements are legal in California. California tried to outlaw them. They got struck down. So if you want to have arbitration, you can do it. You can require your employees to do it. You can even send them an email that says, hey, here's our arbitration agreement. Even if you don't sign it, if you're still working here in 30 days, you're bound by it. I love doing it that way. Most employment claims can be subject to arbitration, which is great, but there is an exception now under the federal law for sexual assault and sexual harassment, okay? In some ways, this is helpful for all of you because one of the big sort of pushbacks among many employers was they were concerned about being accused of covering up sexual harassment and accused of sort of trying to push those things in arbitration where they'll be out of the public eye. Well, now you can't do that. So employees have the option of either going to arbitration or not. And so if you're talking to general counsel or it's people higher up in your organization, they say, oh, well, we don't like the optics of it. And I can say, look, that's really sort of out of the question. It sort of simplifies things. Next big thing. Arbitration agreements still defeat class actions. Now, ideally, your arbitration agreement will explicitly say you can't bring a class action, but even if it doesn't, the law is now clear that there can't be a class action, which is super powerful. I'm gonna talk about that next. Second, we now know it's not going to defeat PAGA. So all of you are probably familiar with that terrible law, the Private Attorney General's Act, which basically allows somebody who suffered one violation of the labor code to then sue for penalties on behalf of all other employees over every other violation of the labor code, and there's sort of extensive penalties for that. And class actions, arbitration agreements are not going to defeat that, but we'll talk about how it kind of helps a little bit. Now, that said, highly recommend arbitration agreements. It's legal, but California keeps trying to, nibble away at the edges as much as they can. They keep getting pushed back by federal courts, but they're continuing to sort of attack it. And so you do need to sort of follow some very particular rules. And so it's a good idea to probably call counsel to make sure that you're following all the rules, to make sure that you're actually going to be able to enforce the arbitration agreement that you spent so much time rolling out. And in particular, courts are really looking to make sure your arbitration agreements are fair. And so if you say, gosh, it would be a great idea to have an arbitration agreement, and you give it to your business people, they say, oh, this is great. Can we make them, waive punitive damages and agree that only we can get injunctive relief and everything has to be totally confidential? Those should sort of set off alarm bells because courts look at those things and say, that's kind of unfair. It's making arbitration less fair than court, and we're not going to enforce the arbitration agreement. So before you start adding in those extra bells and whistles, call us or somebody who knows what they're talking about. Okay, so here's sort of a sales pitch for you, okay? Imagine you have a workforce of 1,000 employees, okay? They make $20 an hour and about 20% of them turn over every year, and somebody messed up the meal breaks. They gave them at the wrong time. You've got a policy that says they're not actually off duty, whatever, weird things come up. Well, what happens? So without arbitration, what you're looking at is liability going back 4 years for all the unpaid wages, all the penalties, as well as all the big PAGA penalties. With arbitration, what happens is that plaintiff has to go to arbitration individually. They can't represent the other 1,000 people. And only if they win in arbitration can they then pursue PAGA. So let's talk about it in dollars and cents. So for a class action, just that one little mistake, and by the way, usually there's a whole bunch of other mistakes, about $27 million plus interest plus attorney's fees, okay? That's in the class action. PAGA, you're looking at about $12.5 million. So if you don't have arbitration, your potential liability is $39 million. If you do have arbitration, it's still a lot because of PAGA, but it's only $12.5 million. So if you're doing the math at home, that's a 68% reduction in your potential liability just because you rolled out this one little simple agreement, okay? And on top of that, now that you're in arbitration, you're going to get to decide whether that plaintiff actually suffered a violation of the labor code in a more informal setting. The arbitrator is less likely to agree with them because they're going to be a little more skeptical. And then only if they prevail, then can they pursue PAGA. And then once you're in court for PAGA, the court has jurisdiction to reduce the penalties. And so that 12.5 could very easily get reduced to say like 1. And so just through having an arbitration agreement, you've reduced your potential liability to a huge extent. Okay, so there's one sales pitch. I can give you a lot more if you're interested. Okay. That said, California still doesn't really like arbitration. They keep trying to get rid of it. They tried to make it illegal. That's struck down. That's not the law anymore. The U.S. Supreme Court held in a case that if a plaintiff is forced into arbitration, their PAGA claim fails, but they said, well, we're going to let the California courts weigh in. No surprise, when California weighed in on it last year, they said, no, that's not the way it works. But what they said is that the plaintiff first has to arbitrate. If they win there, then they can go into court to pursue the PAGA. Now, here's this other law. Big thing. If any of you have cases, if you already have an arbitration agreement, be very on top of paying the fees, okay? Because there's a California law that says, basically, once the arbitration provider sends out an invoice, you have to pay it within 30 days. And they are construing this strictly. So there was a case where the employer mailed the check within 30 days, and it arrived on like day 32. And the court said, nope, you're out of arbitration and you're liable for all the plaintiff's attorney's fees up to that point in arbitration, and they get sanctioned. So you should be very, very prepared to pay the fees immediately, like the day the invoice comes, because there was another case where the employer went onto the website with the credit card to pay the fees, and the website was broken. And so they called AAA and were desperately trying to get it worked out, and it took a few days, and they finally paid it after the 30 days. Got kicked out of arbitration. So don't delay, okay? We will help you. We will remind you if necessary. We will front the fees, but just be ready to pay those bills right away. Here's another key thing to think about, especially if you already have arbitration agreements. Typically speaking, when you're looking at an arbitration agreement to decide if it's fair and it's enforceable, you just read the arbitration provision. So like you have in a big long agreement, you got the one paragraph that says arbitration. The courts historically have just looked at that paragraph. They haven't looked at any other documents that were signed at the same time. But recently, in this Alberto case, the court looked at all the documents. So like very often when you onboard someone, you give them a stack of paper, right? They looked at that whole stack of paper and they thumbed through and they found a couple of provisions that they didn't like in other agreements. So in this case, there was a confidentiality agreement separate from the arbitration agreement that arguably would have kept the employee from being able to gather evidence, talk to other employees. And they said, that's unfair, therefore the arbitration agreement fails. So when you're putting together your start package or your onboarding package, it's a good idea to have somebody look at it with an eye towards making sure your arbitration agreement is not going to be affected by this, okay? And then here's another sort of like procedural thing, probably a little less important for you, but it used to be if a company brought a motion to compel arbitration and they lost, they got an automatic right to appeal and the litigation was stayed. So we always said like, it's worth a shot because if nothing else, it's going to kind of slow things down. Well, California kind of realized that and they got rid of that rule. So there's no more automatic stay if you lose. So all the more reason to make sure your arbitration agreement is enforceable from the get. Okay, so here's your conclusion. Arbitration is great. Feel free to call me. I'll tell you about how great it is. If you're getting pushback about it, we can talk about it. By the way, something like 60 to 80% of non-union employees around the US are already covered by arbitration. So if you don't have arbitration, you're actually in the minority. All right. And, but there's a lot of ins and outs. These are just some of the changes. We talked about so many other changes. There's a lot of ways to get tripped up very easily. So you gotta kind of review your agreements carefully. And the basic bottom line when you're reviewing the agreements is just make sure that you're not trying to get any kind of advantage through the arbitration court. I mean, sometimes the simplest thing is just to say, we will decide all disputes through arbitration at the end and not do anything more. But we're happy to take a look at all your papers and make sure you're in good shape.